Okay, well, welcome everyone to our event, The Decline of Mercy in Criminal Justice and Public Life. My name is Chloe Knox, and I'm the Vice President for Speakers for UVA's Federalist Society chapter. The Federalist Society for Law and Public Policy Studies is a group of conservatives and libertarians interested in the current state of the legal order. It is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Today, we're joined by the Honorable Stephanos Bibas of the U.S. Court of Appeals for the Third Circuit. Judge Bibas was appointed to the bench in November of 2017. Before his appointment, he was a professor and director of the Supreme Court Clinic at the University of Pennsylvania Law School. He previously taught at the University of Chicago Law School and the University of Iowa College of Law, and was a research fellow at Yale. He's published 2 books and over 60 scholarly articles. Judge Bibas graduated from Columbia summa cum laude when he was 19 and went on to receive a master's from Oxford and a JD from Yale. He clerked for Judge Higginbotham of the Fifth Circuit and Justice Kennedy on the Supreme Court. Before entering academia, he worked as an associate at Covington and Burling and as an AUSA in the Southern District of New York. Judge Bibas, thanks so much for joining our chapter today. We really appreciate your time. Before I hand it over to you, I'm going to go ahead and remind the audience that you can submit questions throughout the judge's remarks via the Q&A function at the bottom of your screen, or you can raise your hand and I can unmute you to ask your question when it comes around to Q&A time. But for now, I'm going to go ahead and pop off the screen and turn it over to Judge Bibas.
Thank you, Chloe. Thank you, everyone. Please wave a hand or let me know if I have any audio difficulties. I'm very pleased to be here talking about the decline of mercy in criminal justice and public life. My background is as a scholar of criminal procedure, and my first book is in part about the history of our criminal justice, but I'm also going to try to connect it up more broadly to our public culture, the First Amendment culture that sustains this country. The principle I want to start with is there's something very deep in our history about the importance of judging the act, not the actor. That human beings need to grow and to change. That is where mercy plays a role. I've lamented in my scholarship the decline of mercy, and I think that if we acknowledge the humanity of persons, that's fundamental not only in criminal justice reform, but also in public life, in classrooms, in public fora, and social media. And by the way, the usual disclaimer, I'm not talking today as a judge. I apply whatever the laws are that written, but judges are still allowed to step out of that role, and as scholars or lawyers concerned with the law to critique and to suggest ways in which it could be improved. And it's in that spirit, in a more law reform spirit and a cultural spirit that I speak, not as a judge. So the first half of my talk is about the forgotten role of mercy in criminal law. I want to lay out 3 themes for us to talk about today. The first one is that we shouldn't define wrongdoers by their worst acts. An important principle of the common law is separating the wrong from the wrongdoer. Now, when we go back in time, there are a lot of people, especially on the progressive left, who identify anything old as backwards and anything new as progress. And I want to suggest that that's a kind of a chronological snobbery, as C.S. Lewis called it. That not that we want to go back in all respects. There are certainly things to deplore in our history, but there are also important things we can learn. And one of the deep principles in colonial history is that criminal justice was remarkably focused on punishing wrongs, not depersoning wrongdoers. Punishment, very importantly, was swift and temporary. We have these images of the English bloody code or people being hanged or mutilated. These were actually quite exceptional punishments. In the colonies, unlike England, the code was not merely in theory, but also even less so in practice. The death penalty and banishment were extreme, but they were rarely carried out. In Pennsylvania, where I live, for example, on average, there were only 2 death sentences a year in the colonial era. Only one of those 2 was actually carried out. So most people got some kind of mercy or clemency, likewise for banishment or exile. Same thing is true of some of the extreme corporal or mutilating punishments. The bulk of punishments were fines, apologies, restitution, things like that. If there was shaming, very often it was temporary shaming, not permanent shaming. And I think people have a distorted view from, say, Hawthorne's The Scarlet Letter, especially if you watch the movie. In fact, most punishment was temporary. There was forgiveness after a few hours in the public square of the stocks. After condemning a crime, the colonists, the second half of that was having seen that the crime had been condemned, that the wrongdoer had paid his or her debt to society, the colonists forgave and they reintegrated the wrongdoer. Because their Christian faith undergirded this, there was a sense of the common humanity there, but for the grace of God go I. So the lesson that was taught and the lesson that preachers would draw out very explicitly was the wrongdoers had erred just as anyone could. Not that's a bad guy and you're a good guy, but we're all sinners and we all deserve some punishment, but we all can turn over a new leaf. Today, by contrast, our criminal justice system often comes with permanent collateral consequences. Felons, which is now a permanent class, often can't vote or live in public housing. They must forever disclose their convictions on their job applications, which makes it very difficult to concretely welcome people back into civic life, working life, economic life, etc. My second theme, after the actor distinction, is that we historically have engaged wrongdoers face to face. And that was really an animating principle of the way that our criminal procedure, criminal justice worked. In the colonial era, in the colonial history, morality plays meant that the community was involved in criminal justice. It was very centrally a public, dramatic, cathartic, educated morality play. That centered around jury trials. The public, the ordinary neighbors, the people of the town would sit in judgment. They'd see the victim prosecute pro se, the defendant defend pro se, and they'd render a public verdict. There would also be a public punishment so that the public could see justice done. But again, that would be a temporary punishment of this discrete wrong. Today, by contrast, criminal justice is so highly professionalized that it's become out of sight of average people. Plea bargaining, in particular, it leaves a limited role for outsiders. It's hurried conversations in a courtroom hallway or over the telephone or by email. There are very few jury trials left, 3%, something like that, of felony cases, even fewer of misdemeanors, it's 1% or less. And so the pillar of the Declaration of Independence and Article 3 and the Amendment is all but extinct. It makes it hard for the public to monitor what professionals are doing in their name, and it's hard for them to see and engage wrongdoers face to face. My third theme is that while there is some room for backward-looking retribution, we mustn't let that be exclusive and get in the way or foreclose forward-looking purposes of punishment, like reform, reconciliation, and healing. The colonists did both simultaneously. In colonial history, there were laws on the books that looked quite draconian to modernize, but they were applied with ex post mercy. And there are plenty of good arguments for ex ante perspectives, but they have to be balanced and moderated based on the particular facts of the case, as the colonists did. Judges and juries could accept apologies. They could recognize change. They could nullify even and reduce punishments, tailor it to what this particular person needed and deserved. Today, by contrast, sentencing guidelines, mandatory minima, and the like leave little room for mercy. We can't consider how wrongdoers can change and turn over a new leaf. So that dehumanizes criminal defendants, freezing them forever in time in their worst act in the worst moment of their lives. And very few people are reducible to one act. I want to offer a little digression on this, by the way, because I'm sympathetic in many ways to a law and economics type ex ante focus in many areas of law. I think that you can, in fact, deter tax fraud and make it unprofitable. I think there are lots of corporate and commercial areas of law where that's a very profitable way of approaching things. But having been a prosecutor, I can say I have never met a fully informed rational act. The defendants I prosecuted and the defendants in general in the cases, the run-of-the-mill cases of the criminal justice system, are rarely making a foresightful cost, benefit, net present value discounted kind of decision. As I like to say, who but a reckless risk taker would risk his life, risk getting shot, risk going to prison for years in order to steal $300 and a six-pack from a convenience store, a 7-Eleven. I think that it's very important to remember that 70% of the people in the criminal justice system are mentally ill or drug users or alcohol abusers or some combination. And so there's a deterrence theory that collides head on with reality, especially when we focus on the severity of punishments. It's certainly true that certainty and swiftness matter a lot, but the psychological evidence is lots of defendants are not really thinking very far ahead and discounting rationally in a way that maybe a corporate lawyer or someone in a commercial deal might do that more fully. So I do want to suggest that we shouldn't be as focused on ex ante deterrence to the exclusion of some of these ex post goods. All right, so let's say you're with me. Let's say you think, all right, there's some value to mercy. It ought to at least leaven the system, not swallow it up, but temper the hard edges. Even if that's true, if you buy that point, let's think about what that forgotten role of mercy should be in public life. Second chances matter in criminal law, I've argued, but they also matter in public life. Courts of public opinion are quick to sentence, and they don't really forgive. Technology and social media make it far too easy to tear down not only ideas, but one another. Let's say someone says something that's offensive or rude. How should we react? Let's return to the same three principles that I laid out in the first half of my talk, and apply them to public life and discourse. The first one is, don't define wrongdoers by their worst acts. Separate the wrong from the wrongdoer. Separate the remark from the speaker. As in criminal justice, that doesn't mean that you have to minimize the wrong or say that the remark wasn't offensive or bigoted or whatever. But it's important to remember that everybody has new pages to turn. Give them a chance to write a new story. If you think that we should be giving second chances to wrongdoers in criminal justice, then you should favor the same thing even more so when it comes to someone who's just said something dumb or stupid or offensive. My second point was that we should engage wrongdoers face to face. So let's apply that here to speech. We can't stop talking with those with whom we disagree. They're fellow citizens, co-workers, fellow students. We need to spur dialogue and not suppress it. The remedy historically for bad speech is more speech, not silence. That's a deep part of our First Amendment culture, and that also is deep in our history. In the colonial era, victims and jurors faced their accusers directly. Plea bargaining, as I argued, has all but eliminated that today. But the same thing is true in our 21st century social media environment. The social media and online culture make it too easy to hide behind computer and cell phone screens, especially in COVID time, and to avoid confronting anyone face to face. The speakers instead become abstractions forever defined by their worst act. We dehumanize them and other them, and that makes it easy, very easy, to flame them, to get satisfaction out of it, not to appreciate maybe we're inflicting excessive suffering. Maybe the person ought to be open to dialogue. I think that's a problem with screens, and we should all wish for the day we can be back in person, talking in classrooms and seeing expressions and maybe correcting someone, but that's a face-to-face, human-to-human interaction, not cell phone to cell phone. People are not one-dimensional. They're not two-dimensional. They're not screens. Don't dehumanize your opponents as enemies, even if the offending remark happened to come over a screen, even if you have an impulse to fire back right away. The third theme I had was that we shouldn't let backward-looking purposes of punishment like retribution, or for that matter, rule-like justifications for punishment like deterrence, foreclose some other forward-looking purposes like reform and reconciliation and education and healing. There's a dynamic role. There's a role for people to change through the process of being punished, maybe educated and seeing the errors of their ways. That's a dynamic process that gets foreclosed if we just shut down discussion. So the problem we have in forgetting mercy in public discourse is that we ostracize people too quickly and ban them from re-entering the community. They're wrong thinkers or thought criminals or something. That leaves no room for reflection, for remorse, for apology, for learning. It's a very sad thing that an apology on Twitter is a sign of weakness for other people to pile on. No one's willing to forgive. So we dehumanize those who commit wrongs. Don't foreclose second chances. There should be no civic death penalty. and we should never give up on a person. Those who err need a path to reentry and redemption. So what does that mean for you guys? You're law students, you're close to embarking on your legal career. I want to caution you that at the bar, you're going to keep running across the same people over the years. And they could be friends, they could be opponents, honorable opponents. You could turn them into enemies. Think very hard about that. Even in Manhattan, the biggest legal market in America, at the criminal justice bar, which was maybe the most contentious sector of the law. Even so, people got reputations, and some of them were known to be straight shooters and fair-minded, and that redounded to their benefit. And others were known to be true believers who were intolerant, impatient, wouldn't give an inch, and that also wound up hurting them in the long term. So you got to think about that, what that means for this long-term profession you're entering. Engage with those with whom you disagree. If you feel the urge to tar and feather someone online, which it's an immediate impulse, stop. Go talk with the person. At least pick up the phone, but better yet, to talk to them face to face. Read others charitably. Presume that they acted in good faith. It's often hard to tell that from an email or a tweet. Seek first to understand others before you criticize. I think that lawyers are not as good at listening, really listening and understanding as we should be. And it's a crucial skill, crucial for counseling a client, understanding client's perspective, but being a good listener is a very important thing to work on. And it means that your criticisms will come from a much more solid place. Someone understands that you took the time to listen, you understood where they're coming from, and then they can understand why you have some concern to what the person said. Think also about how people's different backgrounds and upbringings inform their views. Someone comes from a different cultural background. You may be taking a remark one way, and it may look different from where that person comes from. That's another part of really listening. And treat those in general on the other side with the same respect and dignity with which you want to be treated. I think, by the way, and now I'm a little more into personal editorializing, which is very clearly not, descriptive of what the law is. But for those of you who have some kind of faith background or tradition, think about that. Most of the world's religions have this understanding of people having some dignity, having been created by God or a creator. And, my faith tradition certainly teaches that people are made in the image and likeness of God, something that goes back to Genesis. If you understand that we all have flaws and fallen, you'll be a little more forgiving, perhaps. We all have flaws and are fallen, thus we all have room to grow. We must be good to one another, even when they're not, at least initially, good to us. Thank you for your attention, and I look forward to your comments and questions.
Well, thanks so much, Judge. We appreciate it. And if the audience members, if you would like to ask your question aloud, you can use the raise hand function at the bottom of your screen, or you can type up your questions via the Q&A function at the bottom. I will start a bit and say, when you were in academia, how did you see that element of not judging by labels or having conversations face to face versus, making assumptions of others based on views or based on labels of groups that they were involved in? How did you see that play out in academia versus the criminal system?
It's a very good question. I thought it was very important in Socratic dialogue, where some people would be tempted to take something personally. And I get people have strong views on a lot of issues in the law, but I thought it was very important to play devil's advocate for whatever perspective, to make clear there was another side to a ton of issues in criminal justice, and to create a space where I'd call on people and make it clear, like, this doesn't even have to be what your personal view is. Like, if you're a lawyer for this defendant, what argument do you make? Because you're not always going to have the luxury of just representing the fashionable side or the favorable side. I think these ideological monocultures are doing a huge disservice. And one thing I love about UVA, by the way, is that you guys are far more ideologically diverse. I mean, diverse in a meaningful sense than most of the top schools. And frankly, it's better for your education all around to have people from all points of view, because you don't have the luxury of saying, I think that's an offensive position. Your client, your responsibilities to your client may mean you have to make that argument if you can in good faith. You have to be aware of whether it's going to backfire, whether it's going to work with a jury, but there are times when you can make a plausible good faith position argument for a position or a client with whom you disagree, or a client you might find repugnant, maybe your job. I also found in the faculty lounge, there was a real challenge to make people see that, there are downsides to lots of things, that, letting plaintiffs win in tort all the time imposes some other costs, that, making civil rights laws too expansive fuels a lot of lawsuits, some of which have merit and some of which don't, that there's another side to all of these issues, and it's not always aired. And part of my job as a professor was to try to air it respectfully in the faculty lounge and in classroom questioning too.
Well, great. So I'm going to open it up to the audience Q&A, and I'll start with our first question from Caleb Stevens. He asked, are there any particular tips you would have for listening to understand rather than listening to respond?
Sometimes having a pen in hand can be helpful, trying to summarize what someone's saying in a few points. I have this problem because I'm originally a New Yorker, and New Yorkers love to speak quickly and interpret, pause in the conversation as a chance to respond. It really helped me to clerk for an Alabaman and discover that I thought he was just a little slow or something. He's actually one of the brightest people I've ever met. And this Yankee learned a thing or two from him about not judging people by their accents or appearances. And I'm sure that the Southerners in the audience probably get frustrated that we Northerners, reject a lot of other stereotypes, but some of them are very happy to stereotype Southerners. Think down, take a breath, try to distill in your mind what the person is saying and why, and ask some follow-up questions that are designed to elicit why the person is saying what he's saying before you start to critique it, because you might not completely understand.
Our next question says, you mentioned the small percentage of criminal cases that actually go to jury trial. Are there policies we can pursue that would make the jury trial available to more defendants? Yes,
sort of. I mean, the thing is, it's not realistic, given our caseloads, to go back to a full-blown jury trial, especially since the trials of the colonial era are far shorter and less proceduralized, and there's no way we're wishing all of that away. But I have suggested in writing, I mean, maybe cases that are going to have a sentence of more than 5 years, maybe you could at least start with a jury for sentencing. The most serious cases, the ones in which the public has the most interest, would really benefit from even a few hours of airing the sentencing testimony before the solemn imposition of the sentence. And the other thing is, I do think that there are parts that can be streamlined. I mean, I think, the process of serving as a juror is a very painful one right now. People go down to a courtroom, they fill out all these questionnaires, they wait. I have to admit, I haven't been a trial judge yet. I'm hoping to do some of that work by designation, but a lot of the preliminary work of the questionnaires and weeding out the obvious sources of bias could be done asynchronously, goes up in court, and then you could call the remaining people who have no obvious for cause problem for then more intensive questioning, and maybe some of that could be done by Skype so that people hit the ground running when they come to court. But those are only. Also has to be the case that there's a culture change, because right now judges and prosecutors and defense lawyers, they don't want a lot of trials and almost sometimes penalize people for going to trial, as opposed to saying, our job here is to try some of these cases. But the other thing that would be required probably is to triage a whole bunch of low-level junk out of the system towards, tickets or non-criminal violations. And that's a policy decision for the legislature. I just throw that out as one way that you could do it.
And before I move to the next question, I'm curious, going off of something that you just said about Skyping or Zoom, how do you see that new sort of era of trials as impacting the law?
It's adequate. It's good for some things. For a lot of the background questions, for example, I think you might be able to do some of it, but there really is no substitute for some face-to-face work. But the trial judges I know tell me that they're basically postponing all the sentences because unless it's a plea to time served and someone just needs to get out, because you can't have that same electric effect of the defendant's family and the victim and everybody else being there and looking one another in the eye. So it's fine for arguments on legal motions. It's fine for some preliminary and background stuff. It's probably better than nothing for cases where no one is getting any court, like perfect court, but for stuff that matters to people, some with some emotional content. I mean, I think that stuff needs to be live.
So we have someone raising their hand, and I'm going to go ahead and unmute Elijah to ask your question. Go ahead and ask it, Elijah.
All right, great. Judge, thank you for your comments this evening. My question relates to mercy and forgiveness in particular. The value of that to the defendants, I think, is clear, but I'm wondering if you can speak to the value it may have to the people that have been harmed. I had a sense that forgiveness can be helpful for someone moving past a harm that they received, but I've seen more recently this idea that forgiveness isn't actually important for one to move past a harm that they've received. So I wonder if you could speak to that from a cultural perspective or even from a historical perspective in the law.
Sure. I want to be a little cautious. I do think there is such a thing as cheap grace or cheap forgiveness. I think it can be devalued. I think if it's given out promiscuously with no attention to whether someone is open to it, etc., it can devalue it. I also am very sensitive to the fact that victims or forgivers, offended people, wronged people, mustn't be forced. And you take cases of sexual assault, you take domestic abuse. I mean, there's a power dynamic. And if you go and twist someone's arm to forgive, you're just like replicating the subordination or power dynamic all over. So it's got to be voluntary. Having said that, our system really does a lot to discourage it. And I think there's more it could do to encourage. The first thing is most people are thinking about this at the trial or plea or sentencing stage. And that's an obvious place for it. I think there are parts of restorative justice I like a lot. And the idea of bringing people together when they're willing to talk, to explain how they suffered, to be able to cry, to kind of explain how the crime came about. The apologies can matter. I worry that a lot of judges, the empirical evidence is judges give pretty much the same discount for guilty pleas automatically. And though there's a danger of fakery that I'm very sensitive to, I tend to think people are pretty decent lie detectors about that kind of fakery, and that there'd be more value in calibrating it to, did this person have a fulsome confession of guilt that showed he was open to turning over a new leaf, or was he just reading something his lawyer had written? So, I mean, there are some issues there, but I think the evidence is that at least people who take part in this stuff voluntarily come away feeling better off. The other thing I'll say is a lot of people equate forgiveness with lack of punishment, and it's not always that way either. I mean, there are these restorative justice programs in prison where rape victims, you would think they wouldn't want to talk, and yet they themselves find it very useful sometimes to go into prison to meet with the rapist, to understand they were wronged and why, and know the person's not stalking them. Often these are, relatives or neighbors, or they may have to go back to living with them at some point. Very few people will stay locked away for good. So there's a power dynamic, there's a sincerity issue. There are multiple issues that mean you can't just cookie cutter this, make it into a cookie cutter approach. But culturally, it's very intuitive to large numbers of survey respondents. Historically, it was a big part. And it seems to be one of the factors that most survey respondents say most influences them in terms of how much someone needs. Not that someone needs no punishment after an apology or even after forgiveness, but maybe the person needs less. Maybe he's turned over a new leaf. Maybe he's started to learn his lesson. So.
Oh, great. While you grab your charger real quick, I'm going to go ahead and ask the next question aloud. So you spoke a little bit about the programs and things that they have in prisons. Do you think that the educational and training programs in prisons are adequately pointed towards the goal of forgiveness and preparing inmates to return to society? If not, how can they be improved?
Great question. The first thing is there's very little going on in prison. And so, I find it stunning just how bad that is. But let's see, I find it problematic that the programs there are often take like a social work approach, which not that it's wrong, but it's inadequate. Some of what I find very promising is some of the stuff that like Prison Fellowship Ministries has done, where I think, first of all, the government doesn't have enough money, doesn't have enough time, it doesn't have enough manpower. The First Step Act is trying to address a little of this, but there's so many more people leaving prison than they can address. What some of these groups do, like Prison Fellowship Ministries, they partner a local congregation with a wing of a prison. And there's some establishment clause issues. You have to make sure people aren't treated any better because they belong to one religion rather than another. But if it's a voluntary thing and there's no coercion or concrete disadvantage, you can find it very helpful to have the people from a local congregation who say, look, my religious mission, and Jesus told me to go visit the people in prison. And they go in, they pray with them, they work on some work skills, they work on really confronting the wrongness of what they did. And then when this guy comes out, they help to line up an apartment, a job, maybe delivering pizzas or something, a congregation. And so instead of falling back into the old like group of drug dealers in the neighborhood, they can be in this a more constructive community. And rebuilding community and the social fabric is an important part of what criminal justice historically did, what people feel like it needs to do, and what it doesn't do nearly enough of today. So is it a silver bullet? No, of course not. America has lots of fraying community, but is it a step in the right direction? I think so.
Our next question says, how would you recommend dealing with ideological opponents who disagree even about the value of listening to one another? For example, people who think that even giving their opponents a platform is a problem in and of itself.
This is the question of the day, right? There are a lot of people out there who don't buy the First Amendment anymore. They've bought into this cultural Marxism that says that it's all really reinforcing power structures or whatever. And numerically, they are a small fraction of people in America. Now, some of them have disproportionate power among certain cultural elites, but there's a lot of people in America who are sick of that and who are well-meaning. So, you got to be cautious. You got to be cautious about like whether you're saying something through a megaphone or whether you're saying something in a smaller conversation. I do tend to think, the world would be greater if we could just get rid of Twitter entirely. I don't find that to be a very helpful venue for real conversations. But I also think there are still lots of well-meaning people on the other side of the spectrum. And I don't think you're going to win them all over by being nice. You have to be aware and realistic about that. But at the same time, it is also true that you can defy their stereotypes about what you are. Like, I'm amazed at people who will assume all kinds of things about me because of my religion or because of the judge who appointed me or whatever else. And I just like, you do some growing up, you thicken your skin some. It's not an entire answer against the kind of flaming they may give you. You do have to be, cautious about the way you phrase things and how people might misunderstand it. But you also have to learn a level of spine and backbone that you're not going to be, stand down from things. And I should mention, it's really unpredictable what anything will do and help you in your job, but there are a lot of people out there who will admire you if you stand for something and you can speak something you figure out, the right way and the right tone and the right words to say something in, but you don't back down from an unpopular position. I mean, I happen to think that there are politicians out there looking to appoint people like that to be judges, executive officials, all kinds of things. So there's some obvious immediate downside and cost, but a lot of other people will get that, you stand for something. And honestly, you can't spend your whole life cowering. You have to cultivate some courage too.
Sort of going off that, another question asks, what are your thoughts on cancel culture?
Cancel culture is real. There are plenty of people on the left who say it doesn't exist because no one's trying to cancel the PC pieties that they're mouthing. And I wonder about the extent to which, you know, it is unfortunate that there are legacy, there are progressive and legacy elite media outfits that basically have decided they want nothing to do with it. And now, I mean, I think there's a real question out there for policymakers to consider about the power of big tech to delist or deplatform particular books. There are ways around it, but you have to seek out sources of information. There's a lot of independent-minded writing going on Substack right now from people across the spectrum, and it's really worth reading people who disagree with you, but disagree with you reasonably. There are ways to get, books and articles of different perspectives. The media have made it easy. Just don't default to things. And I find it very sad that there are echo chambers on both extremes of the spectrum. Don't just hang out with like-minded friends. Make sure you listen to other people who are willing to be reasonable. And if unreasonable people try to cancel you, some of your best friends on the other side of the aisle may be able to vouch for you, which is another thing that I think has really proven true in a lot of people's careers, that like, no, this is a reasonable person. Let's not tar him with the same brush as other people.
You spoke a bit about the damage that Twitter has done. Do you think that sort of ease of which someone can be rude or offensive or misjudge behind a screen, do you think that's been augmented by this new virtual reality that we live in a pandemic?
Absolutely. Absolutely. Can't wait to get back to real human interaction. And I do think it's interesting. I think that there certainly is going to be more remote working, teleworking, et cetera, but there's no substitute for being together with people. I'm very blessed that I've been able to find extra rooms in my courthouse and have my clerks there physically, albeit socially distanced, and get together, because I find that collaborating in person, you can discuss nuanced points a lot more reasonably, and the give and take, it always makes my opinions better to have the multiple points of view. I deliberately make a point of hiring people who can, make arguments for lots of different sides. I think it just makes you a better lawyer. One thing I love about the FedSoc is that FedSoc is always inviting people for debates, and people from different points of view, and people who are not FedSoc members. And I just wish that was the norm in our society, hosting real debates, as opposed to, okay, all of you listen while we teach the rules.
Yeah, I think law students here would agree that we are longing to return back to the normal in-person collaboration. The next question says, there seems to be a lot of cultural pressure to avoid association with people who have made mistakes for fear of others thinking you endorse whatever mistake they made. This seems completely counter to the goal of mercy. How can we work against this, especially early in our careers, when there are potentially professional consequences for associating with someone who has made a mistake?
Yeah, there's a lot of prudential judgments. It's hard to give a bright line rule. I think that you should decide on principle whether you think, someone is, if someone is just completely off the rails, that's going to be a rare thing. But far more often, someone has done or said something where don't not be that person's friend if you were otherwise that person's friend. And if your judgment, honestly, it was either the whole thing was blown out of proportion, or it was a single mistake or something else, don't fall for that. The person is not tainted, dirty, evil, anything like that. I think it's worth noting, by the way, that Rod Dreher's explained that a lot of what's going on now is akin to what happened in communist countries, where people would make a public show of progressive pieties that, in private, a lot of them would say that's exaggerated, that's extreme, that's ridiculous. And so the whole communist system actually collapsed very quickly once people realized, well, lots of other people aren't really on board with the Marxist-Leninist dogma. I think the same thing is true a lot about some of the most extreme, most unrealistic pieties on the progressive side. And I think that the best we can do is have a healthy culture of discussing it, and not give in to the run away from somebody. I mean, particularly if it's just someone who's a friend. I mean, it might be a little more concern if it's the particular partner you work for who is just then embroiled in something. But on the whole, like, people can understand that you're a different person, and you choose what kind of work you're going to do. And if you are not that person, just say, I'm my own person, judge me on these terms. So it's not that there's nothing there, but I think it's way overblown in most people's minds.
Next question's from Jacob, who says, following up on the earlier question about no platforming, how can universities police disciplinary integrity by keeping out conspiracy theories and quack science, but avoid turning that into partisan ideological persecution?
It's a great question. Professors are entitled to teach what they want to teach, and they don't have to have, a balance or fairness doctrine. And the remedy for that is just don't take classes with that professor, because at every school there are a few professors who just have an axe to grind. But I really think your UVA, you're blessed that as a public school, the First Amendment automatically protects you. At private schools, they're not bound by the First Amendment, though many have chosen to embrace it themselves. But I think a great place to start is to advocate that. I don't think UVA has formally adopted the Chicago Principles of Free Expression, but some other schools have copied them, and they really mount a robust defense of this. I think all kinds of schools are busy saying, we stand with X, we stand with Y, and they should just say, look, whatever this professor says, whatever the student says, that's on them. We stand for, debate, discussion in a marketplace of ideas, and it's not our job to be busy condemning X or condemning Y, as long as it falls within the very broad range of lawful speech. It's not threats, it's not violence, therefore it's protected. And honestly, the other point I'd make, if you don't buy that, I really think there's a lot to the marketplace of ideas. There's a lot to John Milton's classic defense in the Areopagitica that, this is part of your growing and maturing to be able to have to discern these things. But then there's the pragmatic one, which is, if you go and suppress QAnon conspiracists, their response will be, look, the public doesn't want you to learn the truth. Where there's smoke, there's fire, and it's being covered up, as opposed to let it out in the open, let it flame out. It's crazy. Fine. People are free to believe crazy things, say crazy things. Let conspiracy theorists say some of this stuff, as long as it doesn't get to imminent incitement, and just show as a university that we're better than that. Because the other thing is, I just don't trust a university or anyone with the power to decide when speech is heading down the road of, being offensive or being conspiratorial or anything else. The imminent danger or truth threats, incitement riot type doctrines are all very narrow, deliberately, because in our history they've been used shamefully to shut down people like socialist Eugene Debs around the time of World War I. And honestly, socialism is wrong. It's a very bad philosophy, but let people see that by debating it and shooting it down. Don't make them into the innocent victims of an oppressive policy.
Our next question says, there seems to be a connection between your comments about mercy or charity and understanding others and collegiality on the bench. How do you see mercy presenting itself in your work as a judge vis-a-vis other judges, as opposed to vis-a-vis litigants?
Oh, that's an excellent question. And especially since you might not know, the Third Circuit in particular really prides itself on a very collegial culture. And I do think, look, there is a danger of avoiding conflict. And I want to distinguish between disagreement, the fact of disagreement, substantive disagreement, and then the way you disagree. My job as a judge, my oath is to the Constitution. I don't feel that I can sign on to an opinion whose result I don't support, just in the name of being collegial, right? If I don't think that this is right, then I'm not going to vote that way. But the way I do it, for instance, let's say, sorry, I dropped off. Can you hear me on my iPad now?
Yeah, we can hear you. We just can't see you.
Okay, let me see if I can. I had the iPad going as a backup just in case. Okay, start video. All right, I can't do the video rotation, but this battery will take over where the other one let out. So the Third Circuit's collegiality I was talking about, I think It's a little like what judges tell the holdout juror in an Allen charge. You know, you are never supposed to surrender your honest conviction, but listen with an open mind. Those other judges are jurors in that case are reasonable people too. Maybe they got a point. Can you see what their point is? Consider it thoroughly. Think about whether you're just stuck in your way, and if on reflection, maybe you're persuaded. If you're not persuaded, you give them a fair chance. You read say I'm a dissenter, read the majority opinion with great care. See, like, do I see things differently now? Maybe I do. Maybe I come around. Maybe this is right. You know, I'm not a bankruptcy expert. This other person's a bankruptcy expert. I see what his point is. You know, this is a very close factual issue about whether there was reasonable suspicion or not. Like, I see where they're coming from. But at the same time, I won't say something that I don't believe to be true. And I'll be very careful about it. Like, first time I had to dissent on the court, I went and talked to the majority opinion author and said, you know, I've read this carefully. I've been talking with my clerks, and I just can't come around to your point of view. I hope you'll understand. And he understood. I'd gone through some work to show I took his opinion seriously, and there were no hard feelings. And I think it's the same thing when you're a litigator, which you didn't ask about. But, you know, as a judge, we're offering comments on one another's opinions, and we are careful about what we do and don't comment on. Like, we generally, like, matters of style, that's your prerogative. But substantive errors, of course, we should be commenting on substantive errors. You know, there's this big debate about the extent to which the blue book falls into one category versus the other. But when it comes to litigation, I think I understand a lot why people care, why passions run high. These cases matter a lot. One thing I really benefited from by litigating at the Supreme Court was being in a collegial bar where people could disagree hammer and tongue substantively and just really take apart an argument limb from limb, and yet do it in a tone that it was never pejorative, never used invective. There weren't a bunch of adjectives and adverbs. You never called someone outrageous or crazy or lying or anything else. It was deliberately understated, and the understatedness was actually more effective with the court. And I've seen this too, that I've had to correct litigants for saying the other side's position is based on two lies. The first lie is this, the second lie. And I stopped the lawyer. I said, counselor, your friend on the other side might be in error. He might be mistaken. If you're really strong on that, you might say he's wrong, but don't say he lied. Don't impute a deliberate falsehood to that person without the clearest proof. And the message was an important one. And I think when you're tempted to fire off that email or that tweet, when you're tempted to, you've written that really stinging rebuke in your brief, read it, admire it, then cross it out. That's what revisions are for. A lot of that should be on the cutting room floor. And I think you will find that you do better by having a very neutral, even tone. The court will respect you better. The other side will respect you better. You have to explain to the client why you're not flaming the other lawyer and the other party that they're angry at. But part of your job is civility. And this is a repeat player profession, and your client and you will both be better off in the long run if you realize that. And judges, we're there for life. I'm going to be working for these people with them for 20, 30 years. Believe me, I have different perspectives from some of them. But I learned to talk their language, and I learned to listen to them. And I have a thing or two to learn. I was not a trial judge. And they point out things to me that, like, yes, it is truly, logically, it is relevant to point out this special education student's dismal GPA. But it might be hurtful if that kid grows up and reads his dismal GPA in print. Like, we can leave that kind of fact out. Like, that's a perspective I wouldn't have considered because I haven't had that kid physically in court in front of me. And so they've got points to learn, I've got points to learn, and maybe we'll come to agree and maybe we won't. But listening and taking seriously is important, and also keeping a lot of negative or critical thoughts to yourself, or in my case, to myself and my law clerks. Like, I can blow off steam to my law clerks, but I'm very careful not to say to my colleagues the things that I might be thinking or even share with my law clerks.
You spoke a little bit about writing just now and your perspective on it. A question says, as a fan of your writing style, I'm curious who you look to for examples of excellent legal writing, and if you have any advice for students looking to improve our writing.
Okay, so I'll give you a few books that I ask my incoming clerks to read. And then I'll talk about some people whose style I admire, but also the approach that I would recommend. Ross Guberman is great. Point made, point taken. There's a book, Joseph Williams' Style, 10 Lessons in Clarity and Grace, that's in many editions now. There's the guy, George Gopin, who's a professor emeritus of English and rhetoric at Duke. And on his website, he has a bunch of free articles that he wrote, 30 articles for Litigation Magazine that are great. Scalia and Garner are great. George Orwell's Politics in the English Language, of course, Strunk and White. I really like, both Chief Justice Roberts and Justice Kagan have a keen eye, a good ear, and a connection with their audience. I think Justices Kavanaugh and Gorsuch are heading in that direction. There's really been a movement to kind of more plain English, and so I try to keep my sentences short. I try to keep my paragraphs concise, my headings clear, a clear focus on a particular subject throughout a passage. Linking up the end of one sentence to the beginning of the other. And moving from old information to new, so you gradually introduce the reader, because almost everything you do as a lawyer, certainly as a litigator, is telling a story, and a story needs to proceed bit by bit. I find it's shocking to me how few lawyers really tell a story in their facts section, such that I have to tell the story afresh, and it really does require not just regurgitating what they say, but writing it up as a story of, here's who this person is, and here he came to this corner, and then one day he was this. And so also it means pruning back. Do I need the exact date? Do I need, the color of the car? Can I use a word like the cops all described it as a vehicle? Can I call it a car? Doing the work to just simplify and streamline and, 1 and 2 syllable words, etc. More generally, I think that requires some serious outlining up front. To think through what point am I making and what facts really need to be in there to tee it up, and then what can be pruned. Not everything that was in the bench memo, not everything that was in the briefs belongs in the final, whittled down. It's like a sculpture. You got to chip away everything that doesn't serve the shape you want to reveal. But the final thing I'll say about my writing is I think my secret sauce is collaboration. I have every clerk read a draft of every presidential opinion, and almost every clerk read a draft of every non-presidential opinion. And I find that the back and forth through tracked changes, Microsoft comment bubbles, etc., I don't always take what they say, but I take a lot of it. And part of it's trying to be open-minded, because maybe this turn of phrase, I love it. If one reader doesn't like it, maybe I'll keep it. But if 2 readers have an issue with it, either they don't understand it or they take it in the wrong way, I got to throw it out, because the communication problem is not on my reader. It's my fault as a writer if I haven't made it as clear and as simple and as straightforward as I can. And I'm really very sparing about when I use, I know a lot of $5 words, but I'm very sparing about when I use them for effect, because usually they'll lead the reader to pause and say, huh. And so there has to be a particular reason why I use something like that. I'm not Elena Kagan. I don't have her wisecrack wit, but I certainly can try to make my writing as clear and as punchy and as muscular as it can be. And I think if clarity comes before other things, you'll just prune out a lot of details that nervous lawyers instinctively put in. I should say, by the way, I wrote differently as an academic than I did as a litigator, and I wrote differently as a judge than I did as an academic. As an academic, you have to have lots of footnotes, and your audience is maybe more learned. And so when I wrote an op-ed type piece, it was shorter. And as a litigator, I was more punchy, but I still had to use some footnotes, but I whittled them down. As a judge, I choose not to use any footnotes unless a colleague asks me to, or there's one standard footnote required at the beginning of every non-presidential opinion. In part because I find that footnotes generally take the reader on a digression, and either I make a point of integrating into the text or I cut it, and it brutally forces me to winnow down what I'm going to say and how. Some of it can be in parentheticals, some of it can be tucked at the end of the section, but a lot of footnote ideas could just be cut if you really have a laser-like focus on what you want to get across to my readership. And again, litigators don't have that luxury. Litigators have to think a little bit about side issues that the judge might care about.
Well, great. So I think we'll take one more question before we wrap up before 6. This question says, you mentioned a few areas in criminal law that would benefit from reform. In your view, which of these reforms has the best chance for being implemented and having a positive impact?
Okay. I wasn't clear on whether the question was about the ones I specifically discussed or about my reform ideas generally. If I had to pick an area to reform generally, it's an area that started to get some traction. I'd say it's probably bail reform, in part because, first of all, these are people who are still presumed innocent. Often the pretrial detention dwarfs the sentence they would get for a small misdemeanor. They're going to get time served regardless. And so there may even be some innocent people pleading guilty just to get out of jail. And I think that if we care about, the connectedness of communities and families and work and things like that that matter a lot in my conservative perspective and scholarship, we should worry a lot about, the initial few weeks of incarceration. People lose their jobs, they might lose their apartments, they might lose custody of their kids, maybe temporarily, maybe longer. Some people commit suicide in jail in the first 48 hours, and there are real costs there. And I think that both the monetary cost of pretrial detention, but also the human cost is becoming clearer and more of a bipartisan issue. And the other thing I'll say, GPS technology has just grown by leaps and bounds. It's really cheap now. It's only a matter of a short period of time before you can use GPS tracking on a smartphone you give to somebody to enforce a curfew. It's no reason to lock the person up 24/7 most of the time. So that I'd say is the most achievable and feasible in the short term. The other thing I'd say is, I think there's an increasing attitude towards, let's try to make the punishments for low-level crimes, which are the vast base of the pyramid. Misdemeanors are, 80% of the crimes in the criminal justice system, maybe more. A lot of those could be triaged out of the criminal justice system or triaged out of jail time towards more, apology, restitution, other stuff like that. To do that and to make it meaningful, you might need to make the system swifter and use some apologies and shame and other stuff to retain some kind of bite. But I think that, especially with the monetary and human cost and the racial impact, frankly, this is a time in our country's history when maybe you can get some bipartisan traction on those both the low-level stuff and the front-end issues like bail. I think the longer-term stuff about violent and property crime, which are the big drivers of incarceration, those are much more politically contentious.
Well, Judge Bibas, thank you so much for joining us today. We really appreciate your time. Sorry to the audience members who we didn't get to the last few questions, but thank you so much for all those wonderful questions. We appreciate your engagement.
My pleasure. I'm delighted you had me. Please have me in person next year. I'd love to come down.
Absolutely. Have a good rest of your evening.
You too. Bye-bye, everyone.